morning, I'm Jon Lentz, City & State's Managing Editor, and this is Last Look. I'm joined today by Tom Stebbins, Executive Director of the Lawsuit Reform Alliance of New York. Thanks for joining us today.
Thanks for having me.
So we wanted to talk today about the Scaffold Law. We've talked to a few other folks in recent weeks about this. It's a controversial law having to do with gravity-related injuries at building sites. Maybe you could explain a little bit more about the law and what your stance is on it.
Sure. Well, it's a huge issue, and it really affects everybody. And the issue is the Scaffold Law doesn't really have anything to do with scaffolds. What it does is it holds contractors and property owners absolutely liable for elevation or gravity-related injuries. So if there's an injury on the job, under almost any circumstances, it's the employer's or the property owner's fault. And what that does is it drives up insurance rates for everybody, and it really fosters a lot of abuse in the system. And as you've heard from others, it's driving up costs for contractors, but it's also driving up costs for our public projects, it's driving up costs for our schools, and more, what used to be a price problem where our rates because of the Scaffold Law are 10 times more than they'd be in another state, it's now an availability problem. So people are having trouble even finding insurance. And the idea that companies are making a lot of money, the idea that the trial lawyers brought to you the other day, that companies are making lots and lots of money off this is laughable on its face, because insurers aren't willing to write in this market. I mean, if they were making so much money, why are they leaving? And they are leaving. It's very clear. And more people are having trouble finding insurance at all.
Now you say under almost any circumstances. When does this law apply? When does it not apply? What is the criteria?
Well, the scope is really expanded, which is, I think, part of the reason we've seen this explosion in rates. There's two major cases. One expanded it from elevation-related to gravity-related. And as somebody once joked, that said, so if it happens on Earth, it's my fault. And that's roughly correct. I mean, these are really, it's really expanded in that way, going from elevation to gravity. Similarly, there was another case, Runner versus Walensky versus 92nd Housing Authority, which said that same height rule applies. So if something falls at the same height, it triggers a Scaffold Law claim as well. So in many circumstances, these Scaffold Law claims are triggered, which then has driven up the rates more and more and led to more and more insurers leaving the market.
But are there any cases where it fits those two criteria, along the lines of these two cases, but the law doesn't apply?
In terms of a gravity-related incident where the law doesn't apply?
Right.
There is a particular doctrine of sole proximate cause, which says that if the employee is entirely responsible, then it wouldn't trigger a Scaffold Law claim. But I'll give you a story. A gentleman by the name of Bill Socha, he was building a office building, and one of the employees was fired. And he didn't know he was fired yet, and he came to the work site. He was on the second floor of the work site, and his foreman told him he was fired. That man then jumped off the building. Now, you would say, okay, that's a sole proximate cause, but the plaintiff's attorney there is going to argue, hey, couldn't you have put a net around the building? Couldn't you have put some sort of restraint around everybody who got up there? And that's really unreasonable, and it kind of shows this whole idea of equipment. You could provide equipment, which is something that the trial lawyers are often talking about, is kind of a farce, because you could you could wrap somebody in bubble wrap. There's a million things you could do that aren't practical on a job site, and that's why this law is really far past its usefulness. It started in the 1880s. Ever since then, almost every state has gotten rid of it. Every state has gotten rid of it, and New York is the only one left with it. And that's one of the things I also wanted to address, is that the trial lawyers said that other states have this law.
Right. I think Robert Danzey from the State Trial Lawyers Association said Ohio, in fact, has a stricter law, and there are 7 states that have a similar law.
Which is demonstrably false. That is just patently untrue. The idea that they're purporting to say there is that other states regulate scaffolds, which they do, but as he well knows, the Scaffold Law is not about scaffolds. It's about absolute liability. And no other state imposes absolute liability for elevation-related injuries. None. And he knows that, and I think anybody who watches City and State Last Look knows that the Scaffold Law isn't about scaffolds. It's about absolute liability.
Well, he also talked about insurance companies, and he's saying a lot of the criticism is coming from them and that they are making plenty of profits. They have plenty of money. there is the charge that they're moving out of the state or they're pulling out, but they're actually, they have these corporate jets, they're doing just fine.
Right.
How would you respond to that?
Well, I mean, it's completely untrue. If they were making so much money, why are they leaving? And one of the other things he said, which is just false, is that they are not providing data. The data is there. The data shows that we pay in our state up to 10 times more than any other state for general liability insurance. And that's a cost that's passed on to you. It's a cost that's passed on to everybody. And we pay that because there's such a lack of competition in the market, because so many insurers have left, because they're not making money. And the people that are making the money are the trial lawyers, which is why they really like the law.
One thing he also said that struck me as interesting is a distinction between larger companies and smaller companies. He said the problem is really with these smaller companies. The bigger companies, they're doing a good job, they have a strong safety record, but it's these smaller firms that should be doing more for safety, and that's why you need this law, to protect worker safety.
Well, the smaller companies are really getting pushed out of business, and that's the real problem here. Right now, with fewer and fewer companies able to provide insurance, smaller companies are not able to get insurance. And without insurance, they can't really bid on a lot of jobs. So we're having a lot of smaller companies, specifically MWBE companies, which this was mentioned at the new agenda, are going out of business. Or in the case of some of those companies, seeing a massive explosion in their insurance rates. So that's just wrong. I mean, if smaller companies are experiencing a problem, it's because they're being shut down. I mean, they're being forced out of business because of the Scaffold Law.
But critics would say, or supporters of the law would say, well, the reason they're getting forced out of business is that they don't have the safety record. If they had the stronger safety record, they'd be doing just fine.
Well, that's, I think, one of the fallacies of the defenders of the Scaffold Law, which is that it makes workplaces safer. It doesn't. The data doesn't show that. They haven't produced any data that shows that. And that makes sense when you think about it. If you make people more responsible for their safety, they're going to be more responsible for their safety. And if employers are kind of guilty under almost any circumstances, they're not incentivized to have a safer workplace. So for both the workers and the employers, there's not an incentive towards safety, and that's why we don't see New York as leading the pack in safety. And that was another thing that trial lawyers mentioned, is that New York has all these injuries. Well, if we do, why do we have the Scaffold Law? How is it helping? If we're having all these problems, clearly the Scaffold Law is not doing its job.
Now, at the Lawsuit Reform Alliance, you're also working on a couple other issues. I mean, many issues probably.
Sure.
But maybe tell me about one or two key issues you're also working on right now.
Absolutely. Well, New York is one of the most litigious states and the most litigious country in the world. So we pay so much for lawsuits every year. And a lot of the things are driving these lawsuits. The Scaffold Law is one of them. Another issue is the issue of trespasser responsibility. So the idea that somebody could break into this office, injure themselves when they broke into this office, and then sue city and state for their injuries. That law only exists in New York and California.
And that's like what happened with State Senator Jim Alesi.
That's right. Yeah. That's right. And people say that Jim Alesi wasn't reelected because of his vote on gay marriage, but you talk to anybody in Rochester, and it's because he sued somebody on whose property he was trespassing. And I think for most people, that's just wrong. And I think most people, that's a visceral, they understand that that's wrong. And they understand that that's really a symbol of how much New York is broken and how much our laws really encourage lawsuits.
Mm-hmm. Tom Stebbins, thanks for joining us today.
Thanks so much for having me.
And that's it for Last Look. To check out other Last Look videos, go to our website, cityandstateny.com.